Hello, everybody. Good evening. Good evening. Hello. Welcome. Welcome. Good to see you. Just getting everything set up for tonight as we get going here. Make sure I'm set proper. Welcome in. Welcome. Okay, well, welcome. Hello, hello. How's everybody doing tonight? How are we doing? Hello. Good to see you. I will be turning comments off here, but I thought I would start by making sure I'm in frame and saying hello to everybody before I switch off the comments. It's a little unsettling to be completely starting with 0 comments. So, yes, hello. Here we are again. Yes, indeed. Hello. Good to see you all. Good to see you. Yes, I will be. Thanks, Kristen. Thank you very much. Yes, I will be putting the comments off here in just a few minutes, just so I can read through the brief. It seems to go pretty quick to read through, and then I'd like to do a Q&A to follow. So that has been going pretty well lately. Okay, looks good, everybody? Okay. All right, excellent. Well, we'll find out if we're guilty. Yes, indeed. Yes. Hello from California. Hello, everybody. Hello. Well, welcome. Good to see you. Yes, I did want to just say hello before you can be sarcastic. No, we'll do a Q&A to follow right after I finish reading through the document. I think it's been working out really nicely to read the document because it goes a little bit quicker that way, I think, and then we can do a Q&A. So, oh, that's okay. It's all right. Oh my gosh. All right. Well, now that I see that I'm in frame, I will go ahead, everybody, and click off these comments briefly and then read through this. I will be doing a Q&A to follow immediately afterwards. So hang in there, everybody. I will be back shortly in order to do comments. So let's just get this sorted real quick and just to make sure. Okay, everyone, I will be jumping right on in. It's good to see you all. Thank you for coming by. Again, I'm just popping the comments off here while I read through the document. But I will be coming back on. Hold on. I will be coming back on for Q&A to follow right after. So hopefully I'm still in frame. Okay, so let me dive on in. So welcome in, everybody. Good to see you all. Happy Monday. It's been an interesting day so far. We'll see how things go. All right, so tonight, everybody, I'm taking you through the Colorado 14th Amendment appeal. So we had the Colorado 14th Amendment case. I've done some lives going through the original petition regarding 14th Amendment, Section 3, and Mr. Trump and being on the ballot in Colorado. I did go through that petition, and then we did watch some clips from the actual trial itself. The judge issued an order, and in her order, she held that there was an insurrection, but that Mr. Trump, as the president, was not qualified. The 14th Amendment did not apply to him in that way. As an officer, she had read that a little bit differently. So it was a very interesting kind of split holding. We do have an appeal here from the petitioners, or the appellants have appealed. Also, the appellees have appealed as well. The interveners have. But tonight I will be going through the brief that was filed by the petitioners. I thought they did an amazing job setting out their constitutional law questions. So I will kind of just dive into that I will be doing a Q&A immediately following. So also did want to remind everybody they are hearing oral arguments in front of the Colorado Supreme Court on December 6th. So just keep that in mind. But here we go. This is an incredibly well-written brief, everyone. So I'm happy to be able to go through it. Let me give you kind of a roadmap here to give you some idea. We have the issue presented, introduction, a statement of facts in the case here, a summary of the argument, preservation and standard of review. And I will kind of explain some of these pieces as I go through it, not just reading the document, but also explaining some of the concepts just a little bit. Then we have the argument set out. They have 3 major points. Oath-breaking insurrectionists may not assume the office of presidency. We've got a couple of subsections here. Section 3 covers insurrectionists, former presidents. And then number 3, excluding the presidency and the president from Section 3 would yield absurd results. So I will give you a little spoiler right now. This brief is incredibly well written. So here's our table of authorities that they set out. A lot of cases in here. We have the Heller case, which of course is the Second Amendment case. We have Clinton v. Jones. So all of the big ones are here. Something that's a little bit unique is that they cited the Congressional Globe for the 39th and the 40th congressional sessions. So this was back in the 1860s, so 1866 to 1868. There's quite a bit of that. Referencing back to that, remember the judge had relied on the Attorney General's stance in order to determine that the oath was different, meant to be different, and that the president was not included in that language. Next, we also have multiple Federalist Papers that are cited, and then, of course, multiple constitutional articles, 1, 2, 3, and 6. And so we will get into that a little bit as well. So this is just kind of our overview of it. So I will get started here. And again, I will be doing a Q&A immediately following, but we'll just read through the brief to get us started. So I do have, Deborah, just for you and for everybody, I do have my little sticky note for everyone. So this is the Colorado 14th Amendment case, and this is the appeal. So here we go. Issue presented for review. Did the district court commit reversible error in ruling that Section 3 of the 14th Amendment, which disqualifies people who engaged in insurrection against the Constitution after taking an oath to support the Constitution, does not apply to presidents who engage in insurrection or to insurrectionists wanting to be president? So that's the question that is being appealed to the Colorado Supreme Court. Here we go. Following a 5-day trial, the district court found that the violent attack on the United States Capitol on January 6th of 2021 was an insurrection against the Constitution, with the goal of obstructing the peaceful transfer of presidential power. The district court also found that former President Donald Trump engaged in that insurrection, intentionally inciting a mob to violence in a desperate and unlawful effort to cling to power. By doing so, Trump disqualified himself from holding public office ever again. Section 3 of the 14th Amendment, passed after the Civil War, excludes from federal or state office those who engaged in insurrection against the Constitution after previously taking an oath to support it. But the district court found that Trump engaged in insurrection after taking the presidential oath of office. It should have concluded that he is disqualified from office and ordered the Secretary of State to exclude him from the Colorado presidential primary ballot. Instead, the district court ordered the secretary to place Trump on the ballot. The court held that Section 3's disqualification rule does not apply to insurrectionist former presidents, nor to any insurrectionist running for president, in effect. That this office alone is above the law. To reach this result, the district court had to find, counterintuitively, that the president is not an officer of the United States, that the presidency is not an office under the United States, and that the presidential oath to preserve, protect, and defend the Constitution is not an oath to support the Constitution. This holding was reversible error. The Constitution itself, historical context, and common sense all make clear that the 14th Amendment's disqualification clause extends to the president and the presidency. The Constitution explicitly tells us over and over that the presidency is an office. The natural meaning of officer of the United States is anyone who holds a federal office. And the natural reading of oath to support the Constitution includes the stronger presidential oath. Just trying to make sure I stay in frame as I flip my pages here, everybody. The presidential oath to preserve, protect, and defend the Constitution. The historical record when the 14th Amendment was ratified also reveals an overwhelming consensus that Section 3 disqualified rebels like Jefferson Davis from the presidency, and that the president was an officer of the United States. As for common sense, there would be no reason to allow presidents who lead an insurrection to serve again while preventing low-level government workers who act as foot soldiers from doing so. And it would defy logic to prohibit insurrectionists from holding every federal or state office except for the highest and most powerful in the land. Section 3 does not say that. The framers did not intend that. Trump is disqualified from holding office again. This is an expedited proceeding, and all appeals must be resolved before the Secretary certifies the ballot on January 5th of 2024. Given the type timeline, petitioners filed this opening brief concurrently with their application for review under Colorado Code section. That's Colorado law listed out there. Again, I'm trying to make sure I stay in frame. Okay, everybody. Statement of facts and case. Just make sure I'm in frame. There we go. Statement of the case. On September 6th of 2023, petitioners, Ms. Anderson, Priola, Camarada, Kafer, Wright, and Castilian filed suit against the Colorado Secretary of State and Trump in Denver District Court. The petition challenged the listing of Trump as a candidate for the 2024 Republican presidential primary election ballot. Petitioners asserted that Trump is disqualified from public office under Section 3 of the 14th Amendment because he engaged in insurrection against the Constitution after taking an oath to support the same, and hence is ineligible to appear on Colorado's ballots. Section 3 of the 14th Amendment provides, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof, but Congress may, by a vote of 2/3 of each house, remove such disability." Petitioners, count 1, asserted a claim against the Secretary of State under Colorado law, alleging that placing Trump on the presidential primary ballot would constitute an impermissible wrongful act under the Election Code. Petitioners also originally asserted a claim for declaratory relief against both the Secretary and Trump, but voluntarily dismissed that claim. Trump intervened to defend against count 1, as did the Colorado Republican State Central Committee. After resolving various pretrial, evidentiary, and dispositive motions, the district court held a 5-day evidentiary hearing from October 30th through November 3rd of 2023. With closing arguments on November 15th of 2023, petitioners presented evidence that Trump engaged in insurrection against the Constitution by, among other things, repeatedly praising political violence by his supporters, creating a false expectation that the 2020 presidential election was stolen by fraud, calling his supporters to Washington, D.C. on January 6th of 2021, and then inciting a violent and lawless attack on the Capitol to obstruct the constitutionally mandated counting of electoral votes in a desperate and illegal attempt to stay in power despite losing the 2020 election. Trump denied that he engaged in insurrection. He also argued that he's exempt from Section 3 because it does not apply to the presidency, either to individuals who engage in insurrection as president or to insurrectionists who want to be president. The district court issued its decision on November 17th of 2023. The district court held that it had jurisdiction to decide petitioners' ballot access challenge under 2 sections of Colorado law of the Election Code. Based on a thorough review of the evidence and assessments of witness credibility, the district court found that the January 6, 2021 attack on the United States Capitol was an insurrection against the Constitution and that Trump engaged in that insurrection. Not only did the district court rule in favor of the petitioners on every factual issue necessary to disqualify Trump from the ballot, but it also found the petitioners on every legal issue necessary to grant the petition save for one, noting that the court made findings of fact and conclusions of law on all remaining issues. So, the Colorado Supreme Court could resolve this matter fully and finally without the delay of returning it to this court. For instance, the court held that the petition stated a claim under Colorado law that Section 3 may be enforced through state ballot access laws, that the petition does not raise a non-justiciable political question, and that the First Amendment does not shield Trump's incitement. The district court nevertheless concluded Trump was not disqualified under Section 3 of the 14th Amendment for 2 related reasons. First, because it does not apply to individuals like Trump who had taken only the presidential oath of office before engaging in insurrection. And second, because it does not prevent even oath-breaking insurrectionists from becoming president. The district court reasoned that the terms president and presidency are not specifically mentioned in Section 3, that the president is not an officer of the United States, as that term is used in Section 3, that the presidency is not an office under the United States, as that term is used in Section 3, and that the president's oath to preserve, protect, and defend the Constitution is not an oath to support the Constitution as required by Section 3. Petitioners timely appeal this portion of the district court's decision under Colorado law. B. Statements of relevant facts. Petitioners and Trump each presented expert testimony on the historical meaning of Section 3 of the 14th Amendment. Petitioners' expert was Gerald Magliocca, a law professor specializing in constitutional history at the Indiana University Robert H. McKinney School of Law. He has authored extensive peer-reviewed scholarship on the 14th Amendment, including an article on Section 3 before its recent spike in scholarly interest. His work has been cited by courts and the Congressional Research Service, and he has testified as an expert in a prior Section 3 case. The district court admitted Magliocca as an expert in the history of Section 3 of the 14th Amendment. Trump's expert was Robert Delahunty, a retired constitutional law professor. Delahunty has published no peer-reviewed literature on Section 3 and admitted he was not claiming to be an expert in the history of Section 3 of the 14th Amendment. The district court admitted Delahunty only as an expert in constitutional law and the application of historical documents to the 19th century statutes and constitutional provisions. Sub 1. Evidence on whether the presidency is an office under the United States. Magliocca testified that during Reconstruction, the presidency was considered an office under the United States for purposes of Section 3. He described the consensus at the time that Jefferson Davis was ineligible to be president because of Section 3. Including Congress's decision to deny amnesty to leaders like Davis in the General Amnesty Act of 1872. He recounted an exchange between Senators Reverdy Johnson and Lot Morrill during the debate over Section 3, which clarified that the phrase, quote, hold any office, civil or military, under the United States, end quote, includes the presidency. Magliotta testified that, quote, it would have been odd to say that people who had broken their oath to the Constitution by engaging in insurrection were ineligible to every office in the land except the highest one, end quote. Delahunty, by contrast, took no position on whether the presidency is an office under the United States, but acknowledged that maybe the preponderance of scholars agreed with Magliotta's view. On cross-examination, Delahunty admitted that he, too, would be inclined to think the presidency is an office under the United States, given the Constitution repeatedly refers to the office of the presidency. Sub 2. Evidence on whether the president is an officer of the United States. Magliotta testified that during Reconstruction, the president was considered an officer of the United States for purposes of Section 3. He based his opinion on a review of congressional debates and reports, presidential documents, opinions of the United States Attorney General, judicial decisions, and contemporary newspapers. He cited a legal opinion from Attorney General Henry Stanbury, observing the term officer of the United States in Section 3 was to be used in its most general sense and without any qualification, and that the oath was central to determining whether someone was an officer or not. A second opinion specifically referred to the president as an executive officer. Statements by various presidents at the time, as well as members of the 39th Congress that passed the 14th Amendment, repeatedly referred to the president as the chief executive officer of the United States. Delahunty did not disagree with Magliotta's testimony about any of these historical sources, nor did he dispute that people commonly referred to the president as an officer of the United States when the 14th Amendment was adopted. He acknowledged that Stanbury's second opinion defined officers of the United States as any person who held any office, civil or military, under the United States and took the required oath. Delahunty nevertheless relied on cases interpreting the Appointments Clause, referring to the president appointing other officers, to claim that officer of the United States is a constitutional term of art that excludes the president. Sub 3. Evidence on whether the presidential oath is an oath to support the Constitution. Magliotta testified that the presidential oath to preserve, protect, and defend the Constitution is an oath to support the Constitution for purposes of Section 3. He pointed to a contemporaneous grand jury charge issued by a federal circuit judge in 1870 in a Section 3 case, which instructed that an oath to support the Constitution need not use those specific words, but merely had to convey substantially the same meaning. Delahunty admitted that as a practical matter, the presidential oath includes an obligation to support the Constitution, and that contemporary dictionaries define defend as to support. He nevertheless relied on linguistic difference alone to conclude that Section 3 disqualifies only people who took an oath, including the word support, and does not disqualify people who took the more demanding presidential oath. He provided no rationale or historical evidence for this interpretation. Summary of the argument. Just make sure I'm in frame here, everyone. I'll take a sip of tea, just one moment. The district court found that the violence against the United States Capitol on January 6 of 2021 was an insurrection against the Constitution, and that Trump engaged in that insurrection through intentional incitement to violence. Because Section 3 of the 14th Amendment applies to presidents and the presidency, that factual finding means Trump is disqualified from being president again. First, Section 3 prohibits disqualified individuals from holding any office under the United States. The Constitution repeatedly refers to the presidency as an office. That alone is dispositive because the president's office is clearly under the United States rather than under a state or foreign government. In addition, the historical evidence makes clear that both the framers and the public understood Section 3 to disqualify Confederate leaders like Jefferson Davis from being President of the United States. Second, Section 3's disqualification covers anyone who engaged in insurrection against the Constitution after taking an oath to support the Constitution as an officer of the United States. This includes the President and the presidential oath. For purposes of Section 3, an officer of the United States is simply one who holds a federal office, which the President undoubtedly does. At the time of the 14th Amendment's framing, it was also widely known by presidents, Congress, and the Supreme Court, the Attorney General, and the public that the President was an officer of the United States, and the presidential oath to preserve, protect, and defend the Constitution is clearly an oath to support the Constitution. More fundamentally, excluding the President and the presidency from Section 3 would make no sense. Section 3's purpose was to prevent oath-breaking insurrectionists who have heretofore held high official positions from taking office again and subverting the Constitution from within. We are citing the Congressional Globe 39th Congress of 1866. There would be no reason to prohibit insurrectionists from serving as mere presidential electors and from holding every other office in the land while allowing them to hold the most powerful and hence most dangerous office. Nor would there be any reason to allow insurrectionist former presidents to hold office again while excluding former low-level state officers. Preservation and standard of review. Petitioners argued consistently below that Section 3 of the 14th Amendment prohibits those who engage in an insurrection against the Constitution after taking the presidential oath from serving as president again. Interpreting the Constitution is a matter of law reviewed de novo by this court. De novo means of the new. Argument. Number 1. Oath-breaking insurrectionists may not assume the office of the presidency. Section 3 prohibits a disqualified individual from holding any office, civil or military, under the United States. Text and history establish beyond doubt that this broad language includes the office of the presidency. Footnote number 1. Leading 14th Amendment scholars have established this point, and we're citing a manuscript here in that footnote number 1. Sub A, the Constitution's text establishes that the presidency is an office. We know that the presidency is an office under the United States because the Constitution repeatedly says so. The Constitution refers to the presidency as an office 25 times. See U.S. Constitution, Article 2, Section 1. The president shall hold his office during the term of 4 years. No person except a natural-born citizen shall be eligible to the office of president. Neither shall any person be eligible to that office who shall not have attained the age of 35 years and been 14 years a residence within the United States. See also Article 1, Section 3. The office of the President of the United States. Article 2, Section 4 amends 12, 22, 25. See also Federalist number 39, 66, and 68, Hamilton and Madison, repeatedly referring to the president as holding an office. Given Section 3's focus on constitutional oaths, it is particularly notable that the Constitution requires the president to swear prior to the execution of his office to faithfully execute the office of President of the United States. Section 3 thus applies to the presidency. It prohibits disqualified individuals from holding any office, civil or military, under the United States using deliberately broad language that permits no exceptions. And they're citing the U.S. Constitution, Amendment 14, Section 3, and also U.S. v. Gonzalez, 1997 case. Read naturally, the word any has an expansive meaning. That is one or some indiscriminately of whatever kind. Nor can there be doubt that the president's office is under the United States. Section 3 uses under the United States only to distinguish federal offices from offices under any state. Again, citing the 14th Amendment, Section 3. Other constitutional provisions using the phrase office under the United States make it clear that the phrase covers the presidency. If the presidency is not an office under the United States, then a president could 1. Simultaneously serve as both president and as a member of Congress, Article 1, Section 6. 2. Accept emoluments or even titles of nobility from a foreign sovereign, Article 1, Section 9. Hold office as president but no other federal office, despite previously being impeached and removed from office, Article 1, Section 3. Serve as a presidential elector in his own re-election, Article 2, Section 1. And face a religious test as a qualification to his office, Article 6. These outcomes would have been unthinkable to the Constitution's framers. And we're citing the McCullough versus Maryland case, which is one of the landmark cases establishing jurisdiction and the constitutional authority. Rejecting reading of the Constitution that would have resulted in so gross an absurdity, it could not be imputed to the framers of the Constitution. Instead of addressing the textual proof that the presidency is an office, the district court relied on the fact that Section 3 does not specifically mention the presidency. But there would have been no reason to specifically enumerate the presidency because it so clearly falls within the general language of any office. And then we're citing a 2017 case, quoting, the expressio unius canon applies only when circumstances support a sensible inference that the term left out must have been meant to be excluded. For the same reason, it is unsurprising that Section 3 does not specifically mention Supreme Court justices. They too are covered because they hold offices. And then they're citing Article 3, referring to federal judges as holding their offices and to their continuance in office. That stands in sharp contrast to senators or representatives in Congress and electors for president or vice president. The framers needed to enumerate those positions precisely because they were not obviously offices. Electors do not hold office. They are selected for a discrete purpose and a single vote, after which their duty is discharged. Article 2, Section 1, citing Fitzgerald v. Green, electors are no more officers or agents of the United States than are the people of the states when acting as electors or representatives in Congress. Similarly, the Constitution nowhere refers to senators or representatives as holding office, and in fact implies they do not. See Article 2, Section 1. No senator or representative or person holding an office under the United States shall be appointed an elector. The district court also reasoned that Section 3 presents the disqualified offices in descending order of importance, and that it was therefore unlikely the presidency fell in the any office language at the end of the list. That is not correct. The order simply appears to track the structure of the original Constitution. It begins with Congress, Article 1, then discusses presidential electors, Article 2, and finally anyone who holds any office under the United States, Articles 2 and 3, or under any state, Article 4. Certainly, presidential electors are not more important than Supreme Court justices who, like the president, fall under the catch-all any office. In short, the Constitution repeatedly declares the presidency to be an office in unambiguous terms that brook no dissent. citing DC v. Trump 2018 case, for purposes of the Foreign Emoluments Clause, the only logical conclusion from the Constitution's text is that the president holds an office of profit or trust under the United States, and determined the answer was yes. Nobody in the debates later suggested that this reading was wrong. In reaching a contrary conclusion, the district court relied on an early draft of Section 3 that expressly referred to the office of president. But it is always perilous to derive the meaning of an adopted provision from another provision deleted in the drafting process. Citing District of Columbia versus Heller, this was the case that incorporated the Second Amendment into DC. At any rate, this history further confirms Section 3 applies to the presidency. The earlier draft provided that those who had engaged in rebellion would be ineligible to hold, quote, the office of President or Vice President of the United States, Senator or Representative in the National Congress, or any office now held under appointment from the President of the United States, and requiring the confirmation of the Senate. And then we're citing the Congressional Globe congressional session in 1866. There are a few notable features of this draft. First, it confirms the presidency was understood to be an office. Second, it highlights Congress's desire to exclude rebels from the presidency. Third, the draft catch-all any office clause was considerably narrower than the final version of Section 3, applying only to offices requiring presidential appointment and Senate confirmation. This general language would not cover the presidency, and so that office needed to be specifically enumerated. There is no evidence that by later broadening this catch-all to include any office under the United States, Congress actually intended to exclude the presidency. The most reasonable inference is that they dropped the specific reference to the presidency once the broadened catch-all made it redundant. Number 2, amnesty debates. Contemporaneous debates also reveal a consensus at the time that Section 3 disqualified Confederate leaders like Jefferson Davis from the presidency unless Congress removed that disability by a 2/3 vote. During the ratification debate, supporters defended the proposed amendment precisely because it would exclude Davis from the presidency. And then we are citing rebels and federal officers here. Rejecting Section 3 would render Jefferson Davis eligible to the presidency of the United States, and there is something revolting in that very thought, end quote. And then we are citing the Milwaukee Daily Sentinel from 1867, defending proposed Section 3 as modest because even Jefferson Davis, unless by some miracle of justice he should first expiate his atrocious crimes upon the gallows, may be rendered eligible to the presidency by a 2/3 vote of Congress. As Reconstruction wore on, Congress began considering whether to enact blanket legislation removing Section 3 disabilities from former Confederates. Both supporters and proponents acknowledged that blanket amnesty would remove Davis's existing disqualification to be president. And we're citing here, opponents of amnesty thought the result was preposterous and cited it as a reason to vote against amnesty legislation. Those who backed amnesty likewise acknowledged that it would make even Jeff Davis eligible again for presidency. And then we're citing an 1871 source here. When Congress passed general amnesty legislation in May of 1872, it included those who had previously held certain high offices, including Davis. John Bingham, one of the principal drafters of the 14th Amendment, declared that if amnesty had gone, thank you, Alan, any further, Jefferson Davis would be made eligible to be the Democratic candidate for president, an absurd proposition that elicited laughter in the audience. And in 1876, a blanket proposal for amnesty to all Confederates failed. with a principal objection being that Davis would be declared eligible and worthy to fill any office up to the presidency of the United States. Opponents of the blanket amnesty made these points repeatedly. The district court suggested that Section 3 would have obstructed a Davis presidency, not by making him ineligible, but indirectly by preventing rebels from serving as presidential electors. But the historical record reveals a consensus that Davis was disqualified, not merely that it should be harder for him to win. Also, Section 3 only covers those who had previously sworn an oath to support the Constitution, and a hypothetical Davis presidential campaign would have had no difficulty finding former rebels who had never previously held public office and could therefore serve as electors. The history thus confirms what the Constitution's text already says. The presidency is an office under the United States from which oath-breaking insurrectionists are disqualified. Number 2, Section 3 covers insurrectionist former presidents. Section 3 disqualifies all who engage in insurrection after having previously taken an oath as an officer of the United States to support the Constitution of the United States. This applies to Trump. Thank you for the gifts, everybody. Because his presidential oath included a duty to support the Constitution, and because the president is an officer of the United States. Subsection A. The president takes an oath to support the Constitution. The Constitution contains 2 oath of office provisions. Article 6 obligates all members of Congress and state legislatures and all executive and judicial officers, both of the United States and of the several states, to swear an oath to support the Constitution. Under Article 6, for most officers, the Constitution does not dictate the exact wording that this oath must take. However, the President must meet this general obligation through a specific and more demanding oath set out in Article 2. He must, quote, "to the best of my ability, preserve, protect, and defend the Constitution of the United States." Article 2, Section 1. By swearing the stronger Article 2 presidential oath, Trump necessarily also undertook a duty to support the Constitution. By definition, one who defends something supports it. And we're citing a 1773 English dictionary. Defend, to stand in defense of, to protect, to support. And we are citing Webster's American Dictionary of the English Language in 1857. Quick reminders, Civil War was 1864. Defend, to support, and maintain here. Trump's expert admitting that as a practical matter, the obligation to defend the Constitution includes the obligation to support it. 19th century presidents repeatedly gave speeches acknowledging that their presidential oaths imposed a duty to support the Constitution. And then we're citing a compilation of messages and papers of the presidents from 1789 to 1897. Volume 2 at 625, President Jackson, Cleveland, Adams, and Madison. The linguistic difference between the oath to support and an oath to preserve, protect, and defend is irrelevant here. If anything, that a former president broke an even more demanding oath would provide more reason why Section 3 should and does apply to him. The historical evidence confirms that common sense intuition that particular words of the oath do not matter to Section 3. A federal judge at the time charged a grand jury that Section 3 is not limited to those whose oaths use the precise words of the amendment to support the Constitution of the United States. And then we've got a public ledger here in 1870. Newspaper reprinting federal grand jury charge. Although there have been slight differences in the forms of these oaths, Section 3 applies to any oath that substantially, though not literally, imposes an obligation to support the Constitution. The President's oath does just that. Make sure I'm in frame, everybody. Oh my goodness, Kristen, thank you. Subsection B, the President is an officer of the United States. Number 1, an officer is one who holds an office. As laid out in detail above, both text and history establish that the presidency is an office under the United States. That conclusion also resolves the related question whether former President Trump was an officer of the United States for purposes of Section 3. A public officer is simply one who holds public office. And then we're citing an English dictionary here, one who is in office, a Webster's American Dictionary here, a person commissioned or authorized to perform any public duty. The structure of Section 3 confirms this understanding. Section 3 has a near total symmetry between the persons disqualified by Section 3 and the positions from which those persons are excluded. Here's footnote number 2. The one clear exception is presidential electors, which are included in the list of barred offices, but not in the list of covered persons. For example, Section 3 covers the position of senator or representative in Congress and individuals who broke an oath taken as a member of Congress. Footnote number 3. The express inclusion of legislative officials in Section 3 is not surprising. Unlike the president, there was uncertainty in the 1860s about whether members of Congress held office or were officers. Similarly, it covers the position, any office, civil or military, under the United States and individuals who broke an oath taken as an officer of the United States. The best understanding of this symmetry is that officers are synonymous with those who hold offices, describing the essential harmony of an office and an officer terms. See also Article 2, Section 4, impeachment of officers results in their removal from office. Judicial decisions at the time confirmed that officer in Section 3 meant anyone who holds an office and swears the required oath. In applying Section 3 to disqualify a county sheriff in North Carolina, Supreme Court drew, quote, the distinction between an officer and a mere placeman by making his oath the test. Every officer is required to take not only an oath of office, but an oath to support the Constitution of the United States. The oath to support the Constitution is the test, citing case law. Similarly, the Florida Supreme Court, in an opinion construing Section 3 as incorporated through the Florida Constitution, defined an officer of the state as a person in a public charge or employment, commissioned or authorized to perform any public duty, under an oath to support the Constitution and government, and to perform the duty faithfully. And this is in the matter of executive communication on the 14th of October of 1868. Because the president holds the office of presidency and swears an oath to support the Constitution, he is an officer under the plain language of Section 3. Number 2, Attorney General opinions. In interpreting Section 3, Attorney General Stanbury's opinions likewise make it clear that an officer of the United States includes anyone who holds an office requiring an oath to the Constitution, including the President. In his first opinion, Stanbury wrote that the term officer of the United States within the meaning of Section 3 is used in its most general sense and without any qualification as legislative, executive, or judicial, including military as well as civil officers of the United States who have taken the prescribed oath. He explained why Section 3's application to federal officers was all-inclusive. The violation of the official oath relates to fealty to the United States, which is broken by rebellion against the United States. Thus, the reason is apparent for including all officers of the United States and for making the disenfranchisement more general and comprehensive as to them. In other words, no former federal official who broke their oath could be trusted to hold federal office again. Stanbury's second opinion was even more direct in equating officer and office. He declared that officers of the United States included includes without limitation any person who has at any time prior to the rebellion held any office, civil or military, under the United States and has taken an official oath to support the Constitution of the United States. Consistent with this broad and common sense view, Stanbury declared the president to be an executive officer. Now we do have footnote number 4 here. So let me go through that really quick. The district court reasoned that calling the president an executive officer cuts against petitioners because Section 3 expressly covers executive or judicial officers of the states, but covers only officers of the United States. That is wrong and is inconsistent with other parts of the district court's opinion. As the district court points out elsewhere, executive or judicial officers of any state in Section 3 was meant to capture a narrower group of officials than officers of the United States. Officers of the United States necessarily includes executive officers of the United States, further confirming the president is covered. Stanbury's opinions provide exceptionally persuasive evidence of the historical understanding. They came in 1867 after Congress sent the 14th Amendment to the states, but before the requisite 3/4 of the states had ratified it. At the time, the Union was organizing constitutional conventions in a former Confederate states that would vote on new state constitutions and on ratification of the 14th Amendment. The Reconstruction Acts provided that no person could vote for delegates to these conventions if they would be disqualified by the proposed Section 3. Stanbury's opinions interpreting the Reconstruction Acts and, by incorporation, Section 3, therefore directly impacted public debates on that constitutional provision, and they were legally binding. Andrew Johnson's cabinet approved Stanbury's opinions and directed the Union Army to follow them. Short of a U.S. Supreme Court opinion directly on point, contemporaneous opinions from the United States Attorney General adopted by the Cabinet and implemented by the U.S. military at the President's command are about the best historical evidence one can get. The district court acknowledged the opinions' importance, but incorrectly concluded that they cut the other way, standing for the proposition that the president is not an officer of the United States. The district court relied primarily on the fact that in both opinions, Stanbury states that officer of the United States includes both military and civil officers who have taken the prescribed oath. The district court reasoned that the referring to the President of the United States as a mere civil officer is counterintuitive, but there is nothing counterintuitive about saying the President, who is both the commander-in-chief of the military and the leader of the executive branch, is either a military or civil officer or both. There is no other type of officer the President could be. The district court also relied on Stanbury's opinion to hold that any doubt about the operation of Section 3 should be construed against its application, but Stanbury was specifically concerned about the scope of the state officials captured by the phrase executive or judicial officer of any state. Quote, I have said that in addition to the class of officers who clearly come within the terms of the Act as judicial and executive officers of the state, there remain a vast body of officers whose status is in some way to be defined, end quote. He had no such qualms about officer of the United States, which uses the term officer in its most general sense and without any qualification. The President is not some fringe, low-level state officer whom the framers of the 14th Amendment may have had good reason for exempting, and for whom the language of Section 3 is not clear. The President either is or is not included. There is no maybe that could warrant resort to a rule of lenity. Moreover, the Reconstruction Acts were retroactively applicable statutes that disenfranchised those who had rebelled from voting in state conventions. In that context, Stanbury concluded that the law was retrospective, penal, and punitive, and therefore should be construed cautiously. By contrast, Section 3 here is not applied retroactively, and it merely fixes a qualification for office. It is not a punishment meant to take away life, liberty, or property. Number 3, other historical evidence. Other historical evidence likewise confirms what the text already makes plain. By the time the 14th Amendment was ratified, the phrase, quote, officer of the United States, end quote, was widely understood to include the president. This usage extends back to the founding, when George Washington was described as the first executive officer of the United States. Citing Federalist 69 by Hamilton, the President of the United States would be an officer elected by the people. But it was firmly established in the 19th century, presidents were regularly called the Chief Executive Officer of the United States, including Jefferson, Jackson, Van Buren, Harrison, Polk, Taylor, Fillmore, Buchanan, Lincoln, Johnson, Grant, and Garfield. And then we're citing pages 17 through 20 here. These are not isolated or meaningless references. They were consistent, came into context laden with significance, and often were close in time to the ratification of Section 3. For instance, President Andrew Johnson issued many presidential proclamations, equivalent to executive orders today, that invoked his status as Chief Executive Officer of the United States as a basis for his power to adopt Reconstruction measures. During Andrew Johnson's impeachment in 1868, the year the 14th Amendment was ratified, members of Congress repeatedly referred to him in the same way, again in a context where the president's status as an officer actually mattered. And then we're citing the Congressional Globe 40th Congressional Second Session in 1868 here. Members of the 39th Congress who enacted the 14th Amendment also repeatedly referred to the president as an officer. This high officer of the government, the president is a mere executive officer of the government. They especially often called the president the chief executive officer of the United States. And then there's multiple quotes in here. Judicial decisions. No court has squarely held that the president qualifies as an officer of the United States under Section 3 of the 14th Amendment. The issue has never come up because we have never had an insurrectionist president. But for nearly 200 years, judicial decisions have consistently referred to the president as an officer. The year the 14th Amendment was ratified, the Supreme Court said, quote, "We have no officers in this government, from the president down to the most subordinate agent who does not hold office under the law, with prescribed duties and limited authorities," end quote. This was a constant refrain from the Supreme Court in the 19th century. Citing the Massey case, the president or some other officer, no officer except president, the president or any other officer of the government. Lower courts likewise referred to the president as an officer. The president himself is but an officer of the United States. And then also citing Ex parte Merriman case. This is where habeas corpus was suspended by President Lincoln. It's a very fascinating case, calling the president that high officer. More recent Supreme Court decisions specifically addressing constitutional issues related to the president have made the same point. Term limits v. Thornton, the Supreme Court held that various clauses of the original Constitution reflect the idea that the Constitution treats both the president and members of Congress as federal officers, 1995 case. And in the Nixon v. Fitzgerald, the court discussed the president's unique position in the constitutional scheme, whose vesting of executive power establishes the president as chief constitutional officer of the executive branch. And then we're citing Clinton v. Jones, Franklin v. Massachusetts, referring to the president as a constitutional officer. Cheney v. U.S. District Court of the District of Columbia, referring to the president and other officers of the executive. And in Ray sealed case, the president is the chief constitutional officer. And we have footnote 5 here. So we'll bump down. Even the district court in this case referred to the president as the chief executive officer of the executive branch. Trump relies on several cases to suggest that officers of the United States must be appointed rather than elected. These cases are irrelevant here because they interpret the president's power to appoint other officers of the United States under the Appointments Clause. Of course, officers who are appointed by the president are not elected because the president does not appoint himself. Language addressing the Appointments Clause phrase other officers has no bearing on whether the president is an officer. Trump recently acknowledged as much in a New York case where he argued both that the president is an officer of the United States and that the Appointments Clause and related decisions have no bearing on that. Question. And they are citing New York v. Trump here, filed June 15th of 2023. While the Appointments Clause cases do not bear directly on whether the president is an officer of the United States for purposes of Section 3, they do establish a useful general test. To be an officer of the United States, an individual must occupy a continuing position established by law and must exercise significant authority pursuant to the laws of the United States, citing Lucia v. SEC. The president satisfies both requirements. The Constitution establishes the presidency as a continuing position, and vests that office with the executive power of the United States, citing Article 2. Number 5, other constitutional provisions. While the district court believed that there are persuasive arguments on both sides, it nevertheless held that the president was not an officer of the United States. In reaching this conclusion, the district court asserted that provisions in the original Constitution using the phrase officer of the United States suggests the president is not an officer in Section 3. This conclusion is wrong on several levels. First, none of the cited provisions of the original Constitution attempt to define officer of the United States, much less say that the president is not one. Appointments Clause. This clause says only that the president shall appoint ambassadors, Supreme Court justices, and all other officers of the United States. Article 2, Section 2. The president does not appoint himself and so is clearly not an other officer of the United States. That does not remotely imply that he's not an officer. Rather, the use of other implies that the president is an officer. Article 6. Article 6 requires all executive and judicial officers of the United States to swear an oath to support the Constitution. But the president does exactly that. He simply does so by means of a more demanding oath spelled out word for word in Article 2. There is nothing in Article 6 suggesting the president is not included in all executive officers of the United States. Impeachment Clause. The clause provides the president, vice president, and all other civil officers of the United States may be impeached. Under Article 2, Section 4, the key word here is civil because the president is both the chief executive officer and the commander-in-chief. He is both a military and civil officer. Article 2, Section 2, because military officers are not subject to impeachment. To avoid confusion, the impeachment clause needed to specifically identify the president, and for the vice president, because they also serve as the president of the Senate, adding them to this list ensures that this legislative role does not prevent their impeachment. Commissions Clause. The Commissions Clause says that the president, quote, shall commission all officers of the United States, end quote. But this clause, situated in a section in a paragraph conveying powers on the president, means only that the president alone and nobody else has the power to commission officers. It does not mean, and no authority suggests, that the president is somehow excluded from the class of officers of the United States, or more than a rule that plaintiff shall serve on all parties an opening brief means the plaintiff is not a party. In any event, the president requires no commission since he is an officer elected by the people. Citing Federalist number 69, written by Hamilton. None of the references to officers of the United States in these unrelated constitutional provisions overcome the natural meaning of the text. Because the Constitution says the presidency is an office, the person who holds it is an officer. And then we are citing case law here. An interpretation of the Constitution in which the holder of an office is not an officer seems at best strained. In any event, these provisions of the original Constitution, adopted 80 years before the 14th Amendment, do not control the meaning of Section 3. And then they're citing New York State Rifle and Pistol Association v. Bruin, which was the Second Amendment case just recently decided by the U.S. Supreme Court. Constitutional rights are enshrined within the scope they were understood to have when the people adopted them. Suppose for the sake of argument that in 1787 the phrase officer of the United States had some technical term of art meaning that was somehow narrower than the holder of an office under the United States. If that were so, the overwhelming textual, historical, and judicial evidence cited above would make clear the sands of time buried that technical distinction well before the 14th Amendment's adoption. Thus, the court need not decide what the term officer means in unrelated provisions of the original Constitution to decide this case, nor does the court need to decide whether Alexander Hamilton was somehow wrong about the prevailing 1780s usage of officer when he called the president an officer of the United States, again citing Federalist number 69. The court need only decide what officer of the United States meant in 1868 and in the context that used the term in its most general sense and without any qualification. Those who adopted Section 3 clearly understood that this unqualified term included president. Number 3. Excluding the presidency and the president from Section 3 would yield absurd results. The text and history of the Constitution all emphatically support the conclusion that Section 3 applies to the president and the presidency, but so too does basic common sense. When interpreting the Constitution's text, courts are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary as distinguished from technical meaning. We're citing the Heller case again. The simplest and most obvious interpretation of the Constitution, if in itself sensible, is the most likely to be that meant by the people in its adoption. Applying straightforward interpretation rather than hyper-technical lawyering and secret code hermeneutics reveals that implausibility of that claim that Section 3 excludes the president and the presidency. The contrary argument must be that even though the Constitution repeatedly says the president holds a federal office, that office is somehow not an office under the United States. What else could it be under? And even though the president holds an office, he is not an officer, and presumably the president is therefore an officer-less office, or that Section 3 was intended to cover only weaker and not stronger oaths to the Constitution. But why on earth would that be? These interpretations would have confounded the people who ratified the 14th Amendment. Nor would such a reading be consistent with the purpose of Section 3. Section 3 is a measure of self-defense. It gives the Constitution a steel-clad armor to shield it and the people from the assaults of faithless domestic foes in all time to come. Those who hold the highest offices can wreak the most havoc on the Constitution. Supporters of the 14th Amendment would have been aghast at the notion that it prohibited a Confederate leader like Jefferson Davis from serving as a county sheriff or as a mere elector for president, but allowed him to serve as commander-in-chief of the very Union that he had so violently betrayed. And Section 3 was intended to strike at those who have heretofore held high official position and who therefore may be presumed to have acted intelligently. It would thus be similarly nonsensical to exclude the former commander-in-chief who engaged in insurrection from its coverage, while at the same time disqualifying former low-level state officials. Exempting the president and the presidency from Section 3 would also conflict with the broader constitutional design. The qualifications for the presidency are the most stringent in the Constitution, including for age, 25 for the House, 30 for the Senate, 35 for the president. Residency, when elected for the House and Senate, and 14 years for the president, and U.S. citizenship, 7 years for the House, 9 for the Senate, and from birth for the president. Reading the presidency out of Section 3 would mean that, unlike qualifications for office, the Constitution imposes a less stringent requirement on the presidency than on virtually every other federal and state officer in the country. No court should adopt an interpretation of the Constitution that has such an absurd result, unless strictly compelled by unambiguous text. Fortunately, in this case, the text and the history all comport with the common sense outcome. Section 3 does not disqualify oath-breaking insurrectionists from nearly all public offices except the highest one, nor does it give a unique free pass to insurrectionist presidents. Conclusion. For these reasons, the court should reverse the district court's determination that Section 3 does not apply to the president or to the office of the presidency. It should therefore order the secretary to exclude Trump from the Colorado presidential primary ballot and from any future Colorado ballot for federal office, unless Congress removes Trump's disability by a 2/3 vote. And that is the end for that, everybody. So let me go ahead and turn on comments so we can discuss this a little bit here. Just one moment. Okay, hello, good evening, everybody. Good evening. Let me get, whoops. Hold on, everybody, 1 minute. Technical problems. Hydrate, yes. Hydrate. Oh my goodness. Okay, here we go. Hold on, we're on a roller coaster. Bear with me here. Get some technical people to help me in the future. I don't know how you all deal with me. Oh my gosh. Okay, hold on. Oh, there we go. Oh, absolutely, everybody. This appeal was amazing. This was so well written. It was very, very well written. I agree completely. Yes, I will drink some tea here. Seemed well reasoned. I agree. I can't believe it's come to this. I agree. It's disheartening, isn't it? Yes, wonderful and strong arguments. Well, and it's, you know, they set it out so simply, but so thoroughly. I thought they did a really amazing job here. Thank you for reading this. You're welcome, Sunny. Can't wait until January. Yes, it'll be very interesting. How can you exclude the highest officer? That's the question, isn't it? I mean, how could they possibly have meant any office except the president? There may still be hope. Yes, I think there's a lot of different angles to come from, for sure. I thought it was incredibly well written, everybody. That was definitely my thought on it. An average Joe would understand this. Exactly, Katrina. And I think that that's really important. I think all of the average Joes and Jolenes need to be able to understand what's going on here. The state has not this power. Yes, I think, I think too, the state, Colorado needs to be able to make its decision. Basically, they say it's only common sense. Yes, I think so. I think what they're saying too is they can understand where the court's coming from, but that she was wrong. Could the wording of this court case be used for other states going forward? Absolutely. Absolutely, Brandon. Definitely. And they used in this brief multiple quotes from other cases, even the case in New York, which I thought was brilliant to bring in that language. So absolutely helpful. A great starting point, great reference, just incredibly well written. Found a case from 2020, Old Post Office, where Trump said he was an officer. Yes, Hawk. Yes, that's also what they were pulling in here. Is they're saying, well, he even referred to himself as an officer in court. So, like, wait a minute, like he can't argue it both ways. Bumblebee, I agree. I thought it was very well written. I don't know she was wrong as much as she didn't want to be the one to decide. I think you hit the nail on the head with that. I think she took maybe the road that was the best road for her to take, because I think no matter what, she knew it would go to the Supreme Court. I think she set things up for it to be in the Supreme Court. The issue needs to be decided federally, not just a handful of states. Well, Daisy, that's what makes this whole thing, so unusual, and our government so unusual, because we have the state road and we have the federal road. Because with, of course, the federal road, we've got the Electoral College, but the states determine the electors that go into the Electoral College. So it's just a big mess. It's an interesting blend, maybe is a better... Do you think action will take place nationally? No, I don't think so. I mean, I think eventually it'll make it up to the U.S. Supreme Court. I think that will be the national situation. Once the Supreme Court gets a hold of it and makes that final decision, I think that's where it will be. Yeah, no matter what her decision, it would go to the Supreme Court. Exactly, Neil. Exactly. That's exactly right. And I think she knew that. And I think her findings of fact, we have read through her opinion, and she did a great job. She was incredibly thorough with it. And I can see her argument. I don't agree with her argument, but yes, it was going to the Supreme Court anyway. Exactly. Does the supremacy clause? Yes, it does. The supremacy clause out of Article 6 just means the Constitution is the supreme law of the land, and that goes forward on anything. That's why this will go to the U.S. Supreme Court, because although they're asking questions about state law here, ultimately they're asking a question about the federal Constitution. So those kinds of questions have to be clarified by the Supreme Court. Will both sides argue in front of the Supreme Court? Yes, exactly. So we have the Colorado Supreme Court oral arguments are set for December 6th, and I'm assuming we will be able to listen in on those. Oh, thank you for the gifts, everybody. Very kind of you. We'll be able to listen to that at this point, and then we will see what happens at the Supreme Court level with Colorado. But ultimately, it's going to walk all the way up. This is it. Trump is playing checkers. Well, yes, I think so. I think, I think she did the best she could with what she had. Is there enough time at this point? So I would say, because this has to be decided by the time the ballots need to be printed, I did not think that the Colorado Supreme Court would hear it this quickly. I thought it would be the turn of the year before the Supreme Court heard it. But because it has been expedited, it's possible. It's actually possible the Colorado Supreme Court could hold in time for it to affect the ballots in Colorado. So it's possible because, again, it's been so expedited so quickly. I don't know what will happen, but if the Colorado Supreme Court comes back and says, we disagree, take them off the ballot, and then the ballots get printed, within a couple of weeks after their holding, and so the state will have to follow the Supreme Court's ruling, the Colorado Supreme Court's ruling regarding printing. It'll still continue to be appealed. It'll still go through all of the process. But the key is what the decision will be by the time the ballots have to get printed. It needs to be fast. Yeah, exactly. She set precedent of a more concrete legal definition of insurrection. She absolutely did. I think she did what she needed to do to set out, certain definitions, but then on the other hand, left this door wide open for sure in trying to figure that out. Well, Housecoat, here's the deal. He'll say it's rigged anyway. We are at a crossroads in this country, because if we're at a point where every election is being just tossed aside without any evidence, that's a problem. That's a fundamental problem here. So, conceding is one thing. Who cares if you concede or not? I don't care if somebody concedes or not. What's important is that votes get counted and that we actually rely on evidence. So that's really the key. Yeah, I mean, Ricky, it's just not. Bye, Ricky. It's just not. Our voting, the integrity of our voting system since the beginning is amazing. And it's it's the single most important right set out in the Constitution. If you look at quantity of how many times it's mentioned and dealt with in the Constitution. So it's so important. It is the fundamental basic piece. That's the key piece, a cornerstone of the Constitution is voting. And so when you call that into question, it's absolutely devastating. Yeah, can't have misinformation. Not today, Ricky. Sorry, Ricky, but bye-bye. Exactly. So, we need to start healing. We need to start having elections. So I would say, everybody, in my view, the most recent election that we just had, right? So we had a whole bunch of, off-year elections that came in, a whole bunch of results. Let me ask you this. Is anyone challenging those results from just a couple weeks ago? Do we have anybody in the United States saying that the election was false, that it was bad, that they're challenging whomever won for just this most recent one? That's my question. For the most recent election, do we have any challenges? Not a single one. Exactly. And that means we're on the path. We have started to rebuild. Yes, where you live. Okay. So maybe one person, but people are looking into it. They're researching it. They're going in. They're not just saying, well, that's it. And especially when we've got huge offices like governor or senator, do we have anyone saying, nope, I won, and not having any evidence? We don't have that. So I think we are starting. It's going to be a long process, but the more elections we can get through without having these huge tossing aside. The Ohio situation was posturing, which of course they're going to do, because of them. But I think the more and more those happen, the better it's going to be. So we had an off-year election. We have those coming in. Every single election that happens, so we've got the primaries coming up in a few months. And are we going to have big people contesting the primaries? The primary votes came out. The more elections we can have that we can get behind us, that people are saying, okay, we're good, the better we're going to be. We're getting back on the road again. So it's going to take some time, but we had in 2020 such a huge question, but then again, we've got more under our belts so far, so to speak, where we've got some, I think we're making progress. I think we're going in the right direction. But, too, if you think about it, in 2016, we had some of the very lowest voter turnout ever. I think it was really a wake-up call for the whole country. That's true. And many can try to say things are rigged. But again, each time we have an election, it doesn't matter what it is, county supervisor, city council, school board, every time an election is held, results are found, evidence is found and accepted, we move forward. It's another step in the right direction. Example has been made to prevent it. I think you're right. I think you're right. Yeah, it's okay to do a recount or challenge. Absolutely, absolutely. And that's how it should be done. You should, if you think the election wasn't done correctly, recount the votes, go through the process. That's what we learned in Bush v. Gore. Like, use the process that we have set in place to do that. So, I mean, that's what we have to do. But then once everything has been recounted, you don't get to keep asking like 100 times. It's like, look, we did the process. The process said it was fine. We can't just do the process exponentially forever. At some point, you have to call it. And that's really what happened on January 6th. It's like, look, dude, we recounted, we redid everything. We're not going to just keep asking because you want to. Like, we went through the process. The process is over now. So I think we're getting there. I think we're getting there. I think, it's going to be a slow process. We're to rule him ineligible after ballots were printed, but before January 6th. That's a lot, Daisy. I would say that's too much to really forecast. So we're to rule him ineligible after the ballots were printed. Right. I really would have no way exactly, Hawk, 60 plus cases. I'm really not sure what would happen with that. I'm not sure what would happen. I think this is going to be a really slow rolling tank. So I don't think there's going to be any big surprises. But I don't know that it'll be necessarily that complicated. They just found out about it on January 6th. Yeah, I don't think so. I don't think so. I think that we would know about it beforehand. They would know beforehand. Yeah. No, I mean, there's no like, oh, January 6th, look, we've got to question the results. Like, no, that doesn't happen. I mean, with the elections the first week in November, there's a lot of time between the first week in November and in January. That's a lot of time, especially for people who are hired just to do the job, just to do the voting, counting up the jobs. Yeah, absolutely, absolutely. So I think we're starting. I think it's slow. I think it's going to be a delicate road, especially with all of the angst. I think there's a lot of angst. There are a lot of hurt feelings. There are a lot of I think, and some people have said, are we on the road for civil war? I wouldn't say we're on a road for civil war, like a civil war. But I think when it comes to families, I think, families have been absolutely destroyed by this. So I think that has already happened. I think that damage has been done. And I'm not sure how to come back from that. I think that's, in my opinion, that's where the true damage is. Like, we can rebuild. We always rebuild in this country. But rebuilding relationships, rebuilding trust, I don't know. I don't know how that's going to work. I really don't. I don't know how people are going to forgive each other and move forward. And friendships too. Exactly. Heavily gerrymandered state, a form of insurrection. Could be. But the thing about gerrymandering is that it's been since the very first day. Gerrymandering's been an issue since the Puritans came over on the Mayflower. So it's important. It's important to keep the gerrymandering, manageable, but it's also an ongoing issue. Right. The Civil War regarding relationships. Exactly. Yeah. I mean, it's definitely, I think people really were like, I get it. We want to understand other points of view, but then we also, hit some hard boundaries. And I'm not saying that's bad. I think it's okay to hit boundaries and be like, well, this is just unacceptable. But, then you have to kind of rebuild and reformulate how those relationships are going to work. From the South. Yeah, exactly. How can you forgive someone when they... Well, yeah, it's hard, Cynthia. It's really hard. Again, you've got those basic fundamental principles. And if someone can't meet you halfway on those fundamental principles, what can you do? It is very difficult. I would say in 2016, I had some very dear friends that had different political ideologies, and that's fine. And we could talk about that and we could disagree about that. But there were some that were so extreme, with their ideologies that there was no way we could meet halfway anymore. And it's unfortunate. But Yes, and I think it's, Linda, I think it's all around the world. I think this idea of this complete, total self-centeredness, I saw the new president of Argentina is like, taking suggestions from his dog and just like ripping through everywhere. I think it's this total and complete self-centered, I don't care about anybody, light it all on fire philosophy that has hit all over the world and is affecting it. Well, right. And see, that's the thing, Irene, is when people start questioning the truth, like my truth is different than your truth. That was one of the questions I had on my first day of evidence. My professor said, okay, well, tell me what the truth is. Like, oh my goodness, are you kidding me? So, there's a lot of different ways of looking at it depending on who you are. So there can be different views on truth, but the problem has been people starting to doubt just basic facts. Just basic facts. So once we had alternative facts come into play, that was the true beginning. That was the true beginning. Because everyone's got a different way of viewing it, right? Depending on which side of the road you're on, you're going to see an accident from a different perspective. But you still can accept that there was an accident. There was harm that was done. So I think the facts that exactly when they introduced that there wasn't an accident or there were no cars, like, wait a minute, we can have different perspectives on what happened. But now that you're taking the cars actually out of it, it's like turned into a whole different world. So it's much more difficult to deal with the fact of just basic denial of basic fundamental principles than changing ideologies. Yeah, I think definitely we had a lot of the quarantining stuff too. There's usually someone factually at fault. True. And that's why we call our juries a fact finder, because it's their job to determine who's at fault. And we can present two different sides of a case, absolutely. But what we don't do is say there was no car. That's what we don't do. We just don't do that. We don't say there was no situation. No, we just say it's a situation. Who did it? Who's at fault? Well, let's figure it out. As opposed to like, nobody, there was no car. Like, that's like Matrix stuff. Like, we can't even, there is no spoon. Like, what are you talking about? Yes. Yeah, I think it's affected a lot of different families. A lot of families, for sure. I think a lot of things have come out that, were always there, but now are being spoken about. And it's a necessary evil maybe, but something that's going to take a while to come back from. It's going to take some time for sure. Yeah, and we always have conspiracy theories, but, conspiracy theories are... I've taken on a brand new life, it's like conspiracy theories times a million. It's a lot more. Memory zapper thing. That would be funny. Oh my gosh, Sean Spicer. Oh my gosh, it all started there. Nobody did it. Exactly. Like I get it. We all have different ways of looking at things, but there's a basic fundamental thing we can all agree on, that the sky's blue. And right now it's like, there is no sky. Like, what? What are you talking about? So it's going to take a little time. Reading these documents and reading them first. Oh, you're welcome, Dolores. You're welcome. You're absolutely welcome. And let me grab my calendar, everybody. Here. So just to remind everybody where we are here. I'm so glad everyone could join me tonight. So tonight, again, we did the Colorado 14th Amendment appellate brief. So, and that was the appellants that filed, not the appellees. I don't have a brief for them. But if you are interested, you can pull that case up online yourself. Now, tomorrow, I will be going through the Carroll versus Trump updates. There are several, everybody. There's some huge evidence updates going on in the defamation case there, the jury instructions. So that will be tomorrow. I'll be going through that. And then on Wednesday, I will be going through the Texas abortion lawsuit. And this is actually... really hot topic right now because I believe the Texas Supreme Court is going to actually be hearing oral arguments this week. I'm not sure exactly when, but I'll go through that whole case, that whole lawsuit there. And then I've got Mr. Thug's RICO indictment for Thursday. So that's kind of our plan. Trump team respond to this? Yes, I think they have already filed. They've filed their appeals already. They just got their brief out quicker than the other side did. So the other side, the appellees may even have their brief out now. I'm not sure yet. I'll have to double check and see. But yeah, they were just quick. They were really quick. Sure. Yes, exactly. So also we had Eastman out of the Georgia case has asked for the Georgia case to be set sooner than in August. So I've got a couple of motions to go over. He didn't have the biggest inauguration ever. Well, I mean, there's just facts. There's pictures. There's photographic evidence. Oh my gosh. You know, we just don't even have to fabricate the moon landing. Like, we actually have evidence of stuff, you know? Like, you can actually see it yourself. Oh my goodness. So, but this will be for this week. Yes, I'm very interested in Texas. I live in Texas. Oh my gosh, yes. Oh, Jan, Texas. Oh goodness. This lawsuit is actually very fascinating. You know, Texas has some laws that are so vague and so poorly written that the doctors are struggling. And so that's what really this lawsuit is about, is cleaning up the language. So to actually expand rights in Texas is going to take a little different kind of case, but to clarify the language is what this case is all about. So where do you find the Colorado appeal? So you can go online. You can just, if you go online into your search engine, let me show you here. This is the case here. So this is the case number right here. So if you put this case number in, so in your search engine, you just put the Colorado, just write Colorado case number, and then include this number, it will pull it up for you. And all of the filings will be available. So you'll want to find a PDF, and you should be able to find it. Glenn Kirshner speak about Aileen Cannon. No, not yet. I haven't. I've really been enjoying his posts lately. I find him very interesting fella, but I'll have to take a look and see what he has to say about Miss Cannon. Oh, we will see. Yes, I know, Elle. It's kind of tough. You got it, Poetic. It's tough times. It's tough times for sure, but we'll get there because justice matters. Well, it does, you know. It does. Yeah, he's an interesting fella. He's very, very interesting. Okay, sorry, Nancy. Quick conclusion of this appeal, please. Oh, sure. So, for Colorado, the district court came in and said, yes, Trump was responsible for insurrection, but she felt, based on the historical evidence, that he was not an officer in the sense that it was meant under the 14th Amendment, Section 3. So they came in with their brief and they said, no, you're wrong. And here's some information explaining why you're wrong. So the office of the president absolutely is covered by the 14th Amendment, Section 3. And so she was wrong. Texas, it will be interesting to hear. I agree. It's a very good case. I mean, as far as the petition goes, in the standings, very, very well written petition in Texas. So I will definitely be going through that on Wednesday. New plea deals made in Georgia trial. Not yet, Annette. I keep my eye on it every day. I pull the docket up a few times to see what's what. But so far, the only thing that's been filed has been Ms. Fani asking for a trial date in August, and then Mr. Eastman asking for an earlier trial date. That's all that's been filed recently. We will see. Yes, Nancy, technically, they both have already appealed. It's just the appellants are the only ones that have filed a brief yet. About the lawsuits to fix map lines concerning the House Rep maps. You know, there are a lot of cases going on with different map lines in different jurisdictions. There are a lot. So you have to be more specific. Did Eastman file for speedy? No. Eastman has, do you think it's a solid brief? Absolutely, Brian. I really do. So Eastman has waived speedy, but is also saying, hey, we shouldn't have to wait just because, Trump's got all these other court dates. We shouldn't have to wait for him. We should be able to get this taken care of, is what he's arguing in his motion, which I think is very interesting. I'm like, hey, all right, let's do that. But we do have some speedy questions. I can't remember. I think there might be just two people left with speedy questions. I'll have to pull that, though, Suze. That's a great question. But yeah, maybe not speedy, but medium-y. Well, right, Lindsay. The thing is, you have speedy where you've got a certain number of months, but then you also have kind of like this medium or mid-level where you still have to get it done within a certain period of time. What time's Thursday? What's Thursday? So Thursday is the RICO indictment that was set out for Mr. Thug. So I think Young Thug, I don't know what his official name is. I'm just referring to him as Mr. Thug. But this is a huge RICO indictment, everybody. Oh my gosh. It's got homicide. It's got attempts. It's got counts of all kinds of stuff going on. So this is a huge RICO case going on in Georgia. So I will be coming back in on Thursday to go through it. So it'll be a little bit, I think it'll be interesting because Miss Fani is in charge of this case too, and she's not messing around. She's not playing around. So it's an interesting RICO case for sure. Are none of them being televised now? Not that I know of. That could change. But at this point, not that I know of. I sent you a funny TikTok. Really? Oh, yes, the scheduler. Oh, my gosh. Yes, that was so funny. Oh, my gosh. Absolutely. Yes. What about the Georgia Cop City RICO case? I'm Water Bear. I'm keeping an eye on that, too. I've not heard any updates. There have been a couple of news articles that have hit over the last few weeks, but pretty vague. I haven't had any further updates from there. That it seems to have really stalled out. I'm not sure exactly what the next step is. I thought they were going to be pulling them in and that they were going to be going in jail, but they're not. You're the best scheduler. I do my best, Lisa. But yeah, I am keeping a track of what's going on with the Cop City case. And again, there's just nothing going on right there right now. But I'm hoping something goes soon. So, Marker Matthew. Well, yes. I think, we'll have to see what happens with that. But I am keeping an eye on it. I've got a few cases I'm trying to keep track of here. So, yeah, well, Fani's not playing around. She, I've seen some of her other arguments that she's made in cases from a couple years ago, and she's just incredibly she is like a scalpel. It seems like sometimes it gets away from her a little bit, but she is so well organized. She knows the law, she knows the arguments she needs to make, she knows what she needs to put on the record for whatever appeals are going to happen. So I'm very impressed. She's very good. She's very good. Happy about the judge's decision. Yes. I agree. I'm still waiting to come through and talk about the new bond agreement too that's coming out. So yeah, I guess what I would say is her lawyering is very elegant, but sometimes it gets away from her. But I enjoy watching her. I think she's great. She's quick on her feet. She's also not afraid to just go for it. Sometimes I think, we get into an academic groove when we are arguing things. So sometimes we just don't let the full bulldog go, but sometimes she does. And I think that that's okay. I was trying to oust her Fani. So yeah, there's a board that we're getting together in Georgia. There was a law passed stating a particular board could ask for the removal of prosecutors. And that's interesting that you raised that, because I believe there's a lawsuit actually that's been filed. And I believe there's been a recent holding on that, even just as recent as just a few days ago on that. Yeah, she's very passionate. She's very passionate, and that's fantastic. I think that is absolutely fantastic. To do that kind of job and to have that level of passion is very rare, honestly, because you have to mute that in order to survive every day doing that job. You've got to kind of keep some of it back. But she's letting that fire out sometimes. It's rare to see, and that's what makes her very unique and special. So I think she's definitely going down a good road. I just hope she keeps some back. You know, she needs to reserve some, keep some in the tank for herself to take care of herself as well. That's important, very important, doing the job as a prosecutor. Those are difficult jobs for sure. Vacation persistence. Oh, absolutely. I'm happy to come on and talk to everybody about what's going on here. It's just kind of a crazy world. So if I can help people understand it a little bit better, I think would be, I hope helps. I hope it kind of reduces the stress a little bit. So, yeah, I agree. Oh yeah, with Ruby especially. So I will go ahead and sign off for now. I'm watching the clock here, everybody. So I will say my closing statements. I will be back again tomorrow, 7 o'clock. And again, we'll do a Carol update. If I have any new updates, by the way, on the gag orders, I will come on and go through those as soon as they come out, as soon as I get those in my hands. So I am keeping an eye. If any new orders come out regarding those gag orders, either DC or New York, I will come back on and go through those as soon as possible. So, but tomorrow I'm planning to go through Carol versus Trump with those updates on the evidence issues and jury instructions. So it should be really interesting. Oh, you're welcome. You're welcome. Thank you to the moderators for coming and hanging out, everybody. And thank you all for coming and visiting. I will be back again tomorrow. Have a wonderful night, everyone. Oh, it's always fun to hang out. So take care. We'll see you tomorrow.